A neighbor called because they heard yelling. That's all that happened. No one was hurt. No charges were ever filed. By the time officers arrived, everything had already calmed down. And by the end of that night, this man's legally owned firearms were gone from his home. No warrant, no judge, no criminal charge. Just two officers, a calm conversation at the door, and a decision that cost him his property for months while he fought to get it back. This happens more often than most Canadian gun owners realize, and almost none of them know the 3 words that could have stopped it before it started. Here's what you actually need to understand about your rights at your own front door, because this is the part nobody explains clearly until it is already too late. Section 8 of the Canadian Charter of Rights and Freedoms protects you against unreasonable search and seizure, and your home receives the strongest version of that protection that exists anywhere in Canadian law. Courts have said this consistently for decades. Your car gets meaningfully less protection than your home. A public space gets less still. Your home is, legally speaking, the most protected physical space you have. That means police generally cannot enter your home and cannot take your property out of it without either a warrant signed by a judge or a specific recognized legal justification that allows them to act without one. So if that is the law, how does a man with no criminal record and no charges end up losing his firearms in one evening? Here's the answer, and it is the entire reason this video exists. There is a recognized exception to the warrant requirement called exigent circumstances. It means a genuine, immediate emergency. Someone's life is at risk right now. Someone is in immediate danger, and waiting for a warrant would put that person at risk. In a true emergency like that, officers are allowed to act without waiting for a judge. That exception is real, and it exists for good reason. Nobody is asking police to stand outside a door doing paperwork while someone is in immediate danger inside. The problem is what happens in every situation that is not that. A loud argument that is already ended, a welfare check requested by a concerned family member, a neighbor who thought something seemed off. None of those situations are automatically an emergency. But in practice, officers in these exact situations have walked into homes, seen a firearm sitting somewhere, and taken it under the broad idea that they were simply being cautious, being safe, doing the responsible thing. Not because a judge authorized it, not because there was an active threat to anyone's life in that exact moment. Because it seemed like the reasonable, careful thing to do. And most homeowners standing at their own door, faced with a calm, professional-sounding officer, simply say yes when asked if they can come in. That single word is the moment everything changes. Here's what most people do not understand about consent. The charter protection that requires police to get a warrant before entering your home only matters if you have not already given that protection away yourself. The moment you say yes, sure, come on in, you have voluntarily waived your Section 8 rights. At that point, it does not matter whether police actually had grounds for an emergency entry or not, because they never needed those grounds. You gave them permission directly. And once you have done that, no court afterward can undo it. Your consent at the door is the single most important moment in this entire interaction, and it happens faster and more quietly than almost anyone expects. So here's what protects you instead. When officers arrive at your door and ask to come inside for a wellness check, to follow up on a call, to quote unquote make sure everyone is okay, quote unquote, you do not have to let them in. You can speak with them through a partially open door or step outside to talk to them yourself. If they ask to enter, here are your 3 words. I do not consent. Say it calmly, say it once, not as an argument, not as a lecture about the charter. Just that sentence, delivered politely and without hesitation. You can follow it with something simple like, I appreciate you checking, I'm fine, and I do not consent to anyone entering my home. If you believe you need to come in, I understand you can get a warrant. That is the entire script. You do not owe an explanation beyond that. You do not need to justify your decision. Declining entry is not suspicious. It is not obstruction. It is the constitutional right that exists specifically for moments exactly like this one. Here's why those 3 words matter so much. Without your consent and without a genuine emergency happening in that exact moment, officers do not have a lawful basis to walk into your home and start looking around. Saying I do not consent does not guarantee they will turn around and leave, but it removes the one thing that would have made an otherwise unlawful entry completely lawful. It puts the burden back where it constitutionally belongs, on them, to either show a real emergency or go get a warrant. There is a trapdoor here too, and it is important to know about it honestly. If officers do have a genuine basis to believe someone inside is in immediate danger, your refusal of consent does not stop them. Exigent circumstances exist independently of what you say at the door. If there is an actual emergency unfolding, the law allows them to act regardless of your answer. The 3 words protect you against a situation where there is no real emergency and an officer is hoping you will simply say yes out of politeness. They do not function as an absolute barrier against a genuine crisis. This is also where firearm storage becomes relevant again, the same way it does in a vehicle. If officers are lawfully inside your home for a legitimate reason, responding to an actual emergency, executing a warrant for something else entirely, and they see a firearm that is obviously unsecured, sitting out, easily accessible, in violation of your storage obligations, that observation can become its own separate issue, completely apart from whatever brought them there in the first place. The 3 words protect you from an entry based on nothing. They do not retroactively fix a storage violation an officer can see with their own eyes once they are lawfully present. If officers proceed to enter despite your clear refusal and there was no genuine emergency, do not physically block them or escalate the situation. State once, clearly, that you do not consent to this entry and then let it happen. Write down everything the moment it is over. The exact words said, whether a reason was given, what was taken, if anything. Get the officers' names and badge numbers if you can. That documentation, done immediately while it is still accurate, is what a lawyer uses to challenge an unlawful entry after the fact. An entry that happened over your clear, recorded refusal is a case that can be fought. A confrontation at your own front door is not. Your home is the most protected space you have under Canadian law, but that protection only holds if you do not give it away yourself. And most people give it away simply by being polite at the worst possible moment. Know the difference between a real emergency and a routine check. Know that you are never required to invite anyone inside. And know your 3 words so that the next time someone is standing at your door asking to come in, the decision is still actually yours to make.